You are welcome to yet another episode of LFN What's Your Say? The leading listening show where we discuss important issues with important people like you. We are still featuring R. Kelly. Real name Robert Sylvester Kelly. Also known as the R&B King. In a case that gripped the nation and sparked global headlines, one of the most shocking elements wasn't what was proven in court but rather what wasn't. Allegation after allegation was leveled at R. Kelly, and yet many of them crumbled under the light of scrutiny. And among the most bizarre and legally confusing claims is the idea that the women in his company, women who lived a lifestyle of luxury and privilege filled with designer clothes, exotic vacations, private travel and shopping sprees were somehow victims of forced labor. Now let that sit with you for a moment. Imagine a group of women, not prisoners of war, not individuals in refugee camps but grown women who lived in high-rise apartments, wore designer heels, ate gourmet meals and traveled the globe with a celebrity. These are not the typical profiles of forced labor victims. But the prosecution wants us to believe that because these women occasionally cleaned up after themselves or wrote letters as alleged by one of them, they were being exploited. This allegation is not just difficult to understand. It's nearly impossible to reconcile with logic, common sense or any fair understanding of what forced labor actually is under the law. Let's begin by unpacking the term forced labor itself. In international law and in the United States federal statutes, forced labor involves the use of force, threats or coercion to compel someone to perform work or services against their will, typically under threat of punishment. It implies danger, deprivation and duress. And this should take place over time. It's a serious crime because it robs people of their agency, their freedom and their safety. But when the government and certain media outlets twisted this definition and tried to apply it to R. Kelly's girlfriends, they cheapened the very concept of justice. They tried to stretch this deeply serious crime to cover situations where there was no violence, no deprivation and no credible evidence of coercion. Let's talk about the allegations. Adjourned Pace claimed that writing letters was a form of labor. But these weren't business letters or administrative work that should be paid for. She wasn't preparing documents for an office or writing for a company. These were personal letters meant for Kelly or for his own private possession, many of which were described in court as containing apologies or declarations of love. Pace herself admitted that she voluntarily wrote these letters, some of which falsely confessed to stealing from him or to having diseases. Admissions that she says were written out of fear that he would leave her or get upset. And yet Pace had the ability to leave the relationship. She was not locked away or confined in any way. In fact, she left the house on her own free will after one particular argument and did not return. So how does writing such personal letters when you have the freedom to leave, access to your family and are engaging in a relationship you initiated under false pretenses amount to forced labor? Let's move to another accuser, Faith Rogers. Rogers testified that she met R. Kelly in San Antonio, Texas after a concert. She was 19 at the time. She said Kelly flew her out, took her on dates and the two began a sexual relationship. Her allegations were that Kelly was controlling, had sexual encounters but with her full consent, and that he exposed her to a sexually transmitted disease. But nowhere in her testimony did she describe any form of labor. She however attempts to twist the narrative by blaming the allegation on one particular day the two lovebirds had sexual relations with a gun lying on the table. Rogers said she lived in Kelly's residences on and off for about a year, during which time she traveled with him, stayed in luxury hotels, and was often allowed to use his credit cards. She described emotional manipulation, but not physical abuse. And she never described being made to do any chores while with R. Kelly or being assigned duties and working long hours. Yet the government labeled her like several others as a victim of forced labor under racketeering statutes. Another woman known in court documents as Jane Doe No. 5 testified about her time spent with Mr. Kelly. She said she was punished by being forced to stay in a room for long periods of time if she broke rules such as looking at other men or using her phone. She testified that she was told when to eat, when to go to the bathroom and when to speak. But even in this testimony, which was one of the prosecution's strongest attempts to show a form of coercion, she did not describe being forced to work, to clean or to perform any kind of task under threat. Her main complaint? That she had to ask for permission to move about the house. That she couldn't use her phone freely. That she had to wear loose clothing in public, and that she engaged in sexual activity which she admitted was consensual at the time, though later labeled it as manipulative or emotionally abusive. Again, while this may sound as controlling behavior, it does not meet the federal definition of forced labor. Let's consider that term in its proper legal context. Forced labor means knowingly providing or obtaining the labor or services of a person by threats of serious harm, physical restraint, abuse of legal process, or a scheme intended to cause the person to believe that if they didn't perform the labor or services, they would suffer serious harm or physical restraint. Did Kelly force anyone to do actual labor? Did anyone testify about 14-hour shifts in a kitchen? Or being ordered to clean a mansion under threat? Did someone say they were made to work a business unpaid and against their will? The answer is no. The labor described boiled down to a few key things. Writing personal letters such as those described by Adjourned. Participating in consensual sexual activity later reinterpreted as exploitative. And performing light domestic routines for themselves or keeping their spaces tidy, which should be normal life practice. Now let's take a closer look at this idea of domestic tasks. Jane Doe No. 3 testified that she lived in Kelly's guest houses in Georgia. She said she had to wait for permission to come downstairs and wasn't allowed to interact with others freely. She did not describe being beaten or physically forced to work. The only extent of the labor she described was cleaning her room, making her bed and preparing her own meal. Imagine the prosecution argued that the rules themselves were oppressive. But these are the same rules you'd find in any strict households, dormitories or any shared facilities, but not on labor camps. There were no chore lists, no penalties and no structured work schedules. These were private domestic spaces, and the labor being described was indistinguishable from everyday adult responsibility. In one of the more dramatic examples, another accuser testified that she was told to keep her area clean and to be quiet when guests arrived. That's it. Imagine that was presented in federal court as a form of labor. The use of the forced labor statute in this context is troubling because it dilutes its original purpose. These laws were written to combat real abuse involving coercion, slavery and unpaid servitude. They were not created to criminalize the dysfunction of celebrity relationships or the structure of consensual but controlling romantic arrangements. Many of the women, including Adjourned, admitted that they wanted to be in a relationship with Kelly. Some returned at their will after leaving. Others kept in contact with him for months or even years. Pace in particular wrote wonderful messages about Kelly on social media before eventually testifying against him. If someone is allowed to travel, receives gifts, voluntarily write letters, choose to remain in the relationship and makes no financial contribution to the household, can they realistically be labeled a victim of labor exploitation? This is not a denial of the emotional trauma some women may have experienced, if any. It's an honest question about how far the legal system is willing to bend definitions to convict someone who is already controversial in the public eye. Prosecutors did not produce employment records. They did not produce task logs or surveillance of anyone being forced to do work. They did not present text messages that clearly showed threats tied to labor. Their entire argument rested on subjective testimonies, often from individuals who contradicted themselves, or who had incentive to paint a particular picture in court. Ultimately, these women were not helpless. They were not living in locked cages. They were not being rented out for labor. Instead, they lived in comfort, and the closest thing to work they were ever asked to do was clean up after themselves and write personal letters. If that's enough to convict someone of forced labor, then the law is no longer about justice but about narratives. Thank you for watching today's video, a production of LFN Media, giving you another perspective of issues at hand. We make it our business to keep you updated with the truth amidst the cloud of lies the media wants you to believe. It is therefore important to subscribe to this channel, hit the bell icon and allow all notifications so that you don't miss out whenever we publish a new video.